Former BJP spokesperson Nupur Sharma finally got interim protection from the Supreme Court on Tuesday. What this essentially means is that she cannot be arrested in the 9 cases that have been filed against her over her comments on Prophet Muhammad. These FIRs have been filed all across the country. The Supreme Court also asked various states to respond to her petition, which basically demands combining of these multiple FIRs against her or clubbing them into one. But why exactly did Nupur Sharma need the FIRs to be clubbed, and what does the law on clubbing of FIRs say? I'll tell you in this episode of KYC on Know Your Constitution. Now let's first understand how all of this began. In May, former BJP spokesperson Nupur Sharma, she's the woman we've been talking about, allegedly made derogatory remarks on Prophet Muhammad. And there was a huge uproar in the country and across the world against these remarks. She was also suspended from the BJP after this. She did apologize and also withdrew her statement, but several FIRs were then filed against her, including in Delhi, Bombay, West Bengal and Assam. She then approached the Supreme Court seeking a transfer of all the cases of hate speech against her to a court in Delhi. Now let us understand why such a petition is usually made, because this has happened in the past. Basically, under the constitution, nobody can be prosecuted for the same offence twice. This is under Article 22, that is 20 subclause 2 of the constitution. The principle is called a right against double jeopardy. It says that, and I quote, "No person shall be prosecuted and punished for the same offence more than once." This is the underlying principle when we talk about any person asking for clubbing the FIRs filed against them on the same incident under the same provisions, because multiple FIRs on the same incident would virtually mean multiple trials on the same issues in different courts across the country. So approaching the Supreme Court in such situations protects these people from excessive litigation, from being harassed. The Supreme Court has also ruled that there cannot be a second FIR on the same issue. This was in the landmark TT Anthony case in 2001. The court had then asserted that there cannot be a second FIR and fresh investigation on every complaint received from the same occurrence or incident. So the Supreme Court basically held that the very concept of an FIR is a first information report, which means that there cannot be a second FIR with regard to the same cognizable offence or the same incident. More recently, 2020, the Supreme Court granted similar relief in Arnab Goswami's case. In Goswami's case, the apex court asserted that subjecting an individual, anybody, to numerous proceedings in different places on the basis of the same cause of action, that is the same incident, cannot be accepted. It said that subjecting someone to such multiple FIRs affects a person's right to fair treatment under Article 14 of the Constitution. Article 14, as we know, talks about equality before law and is used against a safeguard against arbitrariness as well, which applies in this case. The test to be applied in such cases, that is when you want to club FIRs, is that the court is supposed to find out whether both the FIRs or the multiple FIRs relate to the same incident in respect of the same occurrence or are in regard to the incidents which are two or more parts of the same transaction. If the answer to this question is yes, the second FIR or the FIRs that come next need to be quashed. Now, how does the court decide whether FIRs need to be clubbed? The test, as laid down by the Supreme Court, is for the court to ask whether the court asks this question, and it's supposed to find out whether both the FIRs relate to the same incident in respect of the same occurrence, or if they are in regard to the incidents which are two or more parts of the same transaction. If the answer to that question is yes, the second FIR or the next FIRs need to be quashed. But what happened with Nupur Sharma was that when she approached the Supreme Court for clubbing of the FIRs at the start of this month, the court came down heavily on her, saying that, and I quote, "This lady is single-handedly responsible for what is happening in the country." The court said that Sharma can go to the High Courts instead. So Sharma's lawyers withdrew that petition. The court did face a lot of criticism for these remarks. 15 retired judges, 77 former bureaucrats, and 25 former officers of the armed forces issued an open statement as well, calling the court's comments unfortunate and unprecedented. They had said that by approaching the Supreme Court, all Sharma was trying to do was exercise her fundamental rights, right against double jeopardy under Article 20, subclause 2 of the Constitution, which I explained to you. Now, these earlier remarks were made by a bench of Justices Suryakant and J.B. Pardiwala. This same bench has now issued notice on a fresh application that Sharma filed recently, seeking to revive her earlier plea. Now, this was on Tuesday, like I mentioned, after Sharma's lawyer told the Supreme Court that after the court's order on July 1st, genuine and serious life threats were being issued against her, and due to threat to life and liberty, she cannot go and approach different high courts, which is what the Supreme Court had earlier suggested. So the court has now offered that no coercive steps can be taken against her in the multiple FIRs registered against her. And it has also said that the same relief will cover any future FIR or complaint which may be registered or entertained against her with respect to the same telecast or the same remarks. The case will next come up in August. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.